from my memory, I know what the jury's asking, and this is not the witness who gave that information. But what I can tell both parties, this whole transcript is not the answer to this question.
Right.
So the whole transcript is not going to be going back. The only thing that comes close to being the answer, and I don't even think it's the answer, is from page 154. And it's this answer A. Well, I happened to notice a fight in the car. You know, the front passenger was turned around and was fighting somebody in the back seat. And I didn't know who it was. And then the passenger in the back seat jumped out and screamed, helped, and was yanked back in the car. That really got my attention. So it's like, wait a minute, somebody needs help. That's the closest thing that comes to answer the question. The entire transcript is not an answer to the question. So the entire transcript is not going back.
We're agreed with that.
I don't, Your Honor, I don't think the question's specific enough based on what we've reviewed in the transcript for any of it to go back.
Oh, no, I mean, the question is very specific. We're going to go on the record. Court is calling 2019 CR 12495 State versus Taymor McIntyre. Both counsels are here. The defendant is present. The jurors say, and I'm going to take the questions in the order in which they were given. Jurors' first question. We are in disagreement of what the woman who was homeless at the time heard Mark say when trying to get back in the car. So can we have the testimony to the above? That's a specific question. She wants to know, the jury wants to know what the homeless woman at the time heard Mark say when trying to get back in the car. What the court reporter has pulled is question. Okay, and then after that, can you tell me more about the second car and why that car caught your attention? Answer. Well, I happened to notice a fight in the car. You know, the front passenger was turned around and was fighting somebody in the back seat, and I didn't know who it was. And then that passenger in the back seat jumped out and screamed, helped, and was yanked back in the car. That really got my attention. So it's like, wait a minute, somebody needs help here. That's the answer to that question. But again, the entirety of this transcript is not the answer to that question. I understand that people want context, but the court's job when a question is asked about a specific disagreement, it's not for the court to give context. It's just for the court to answer that question through the court reporter's transcript.
Yes, Your Honor, but as you yourself observed, it doesn't appear that the question that the reporter found for this witness is what they're actually disputing about, that they appear mistaken about.
No, what the court is saying is from the court's memory, there's another witness who gave an answer, but for this specific question through the homeless person, this is the answer. And this is the answer from the homeless. And I hate to say, I don't want to just say homeless person, but I'm saying that because that's what's in the question. Yes.
This is excellent.
All right. So that's her answer to their question. Now, do I know that there's another witness who came to testify who said something from their perspective? Yes. But the jurors will need to ask that question and they haven't asked it. So the only question I am focused on is what has been asked here. And the court is not going to send back this entire transcript because that's context and it's not an answer to their question. So the answer to the question is as the court has read it. That's the answer. And if y'all have objections to that answer being sent back, y'all can put it on the record. But what I'm telling you is the entirety of this transcript of that witness is not going to be sent back unless both parties agree that the entirety of this transcript of her testimony be sent back.
We're okay with the answer posed by the court.
And your objection would be?
We would object to just that portion going back, Your Honor. I don't believe that that answer is in direct enough response to the question that we can believe that that question is truly specific as necessary to get testimony read back to the jury. And without the entire transcript, the question out of context, I think, places undue emphasis on a very small portion of the witness's testimony who is in and of herself just one of many witnesses similarly situated who testified in the trial. We believe that that is not what the point of the rule that allows jurors to look at transcriptions of portions of the record they dispute was designed to accomplish. What it's designed to accomplish is to really drive down to, like, was the light red or green? You know, was the answer yes or no? And this is way too vague. in
No,
the
they
grander
said they're in a
context.
disagreement as to what the homeless lady heard Mark say.
Well, I understand, but I think that it, as the court indicated, might not be what they thought it was. And I think it does place undue emphasis. And in particular, we need to keep in mind that, for one, there were two previous objections to the testimony in question elicited, one of which was sustained, one of which was overruled. So I guess for the record, we want that objection noted
Well, what I
again.
can tell you about your objection, counsel, and from reading the entirety of the record, there was no objection at that time to that question. The objection came later in the questioning, and I can tell you what page that is on. So on page 154, there was no objection to the witness's answer. Your objection came in on page 156, where it says question, okay, and then you said you heard the person in the back seat yell help. Is that correct? Answer, yes, ma'am. You objected to leading and the court sustained that. So this answer came well before that objection.
Well, and correct me, Your Honor, I don't know the order. I do know there was a second objection for hearsay that was overruled. I don't know if it came before or after.
After.
Um, my primary objection is that it places undue emphasis on a very small portion of this woman's transcript, and that out of context, it could be misleading to the jury. I don't believe the question is specific enough. We would object to any portion of the transcript going back.
All right. And so it's not when, as both parties know, y'all have been attorneys, when somebody asks a specific question, when they have a specific dispute, they are not given the entirety of someone's testimony because they're not allowed the entirety of the testimony, because then there is no need to have a jury trial with people asking questions in front of a jury. You just give them the transcript to read. So in answer to that question, the court is going to either have the jury brought out, if you want the jury brought out, and I am going to read to them. Well, I happened to notice a fight in the car. You know, the front passenger was turned around and was fighting somebody in the back seat, and I didn't know who it was. And then that passenger in the back seat jumped out and screamed, helped, and was yanked back in the car. That really got my attention. So it's like, wait a minute, somebody needs help here. That's the answer to the question. So I note your objection. Your objection is overruled. The only question now is, do you all want the court reporter to print out that specific section and send it back to the jurors? Or do you want the jurors brought out and have the court read the answer?
If it's just going to be that portion, Your Honor, then it can be printed out, just the answer, and just the answer sent back to them, but without waiving the objections I just made.
All right. So Cindy, with regards to that section, and I will highlight it, that's going to need to be sent back to the jurors. Could you all hand that to her? The next question that came after that, since we can't agree on whether there was a robbery or not, what is the next step in the process if we can't agree on the main charge, capital murder? Both parties had a chance to review the question.
Yes, Judge.
The court proposes the following supplemental charge with reference to your inquiry. You have all the law before you. Please continue your deliberations. Any objection?
Not from the statement.
Your Honor, I think that while that language would be valid, I would suggest that, well, let me begin by saying the language of the question in its totality seems to convey that they are unable to agree as to that charge. And so we would preliminarily move for a mistrial.
All right, that's going to be denied.
And then secondarily, as to the response back to the jurors, I think that we would ask that if we could say, if you cannot agree, if you are not unanimous as to every element of capital murder, you must continue to deliberate about capital murder, because the question seems to be confused about how the charge works. And
All right,
so
so
that's our worry.
All right, so that's going to be denied. And what the court and both of you all aware that the jury charge specifically states you first decide on if you can come to a decision, guilty or not guilty on the capital murder. If the answer is not guilty, then you move to the lesser included offenses. Is that
That is
what
correct.
everyone else interpreted the jury charge?
Yes, Your Honor.
Yes,
That's the
Judge, but
statement.
our concern is that because capital murder because the capital murder portion of the charge does not have the self-defense language in it. I worry that there's confusion about how they're to consider portions of the charge that relate to self-defense as it relates to capital murder. And so by explaining to them that they have to be unanimous as to every element of capital murder before they can move to the other portions of the charge, I feel like that answers their question. It doesn't expand anything that hasn't been previously instructed. And it may clarify that issue.
Right.
Because it does seem like they are, at the moment, deadlocked as to the first indicted theory of the
Oh,
case.
I have no idea if they're deadlocked or not, but closing arguments, that's when you all explain that. You're allowed to explain that. Of course, the court gives the jurors the law, and if you all go afield in your explanation and closing argument on what the law is, that's when I step in. So the court is, for that question, I note your objection. The court is going to send the answer with reference to your inquiry. You have all the law before you. Please continue your deliberations. And I previously stated what the answer will be for the first question as well.
Yes, Your Honor.
All right, we can go off the record, and Cindy, if you can print that section out for me, and both state and defense, if you all look at that and make sure that's the answer we agreed upon.
Yes, Judge.
Yes, Your Honor.
Oh, and both parties, I'm assuming no objection to just sending the questions and the answers back to the jurors?
No, Judge.
All right. All right, we're going to go on the record in 2019 CR 12495, State versus Taymor McIntyre. Can I have parties announced for the state?
Jason Beer, had a big gallery with the shades on it.
He then stepped out.
I'll step out. Good.
Okay. And for the defense?
John Hunter for Mr. McIntyre. Your
Mr.
Honor.
McIntyre, come down.
All right, the court is in receipt of two questions from the jurors. Defense and state, have you had a chance to review the questions?
We had, the state has, Your Honor.
Defense has as well, Your Honor.
All right, the first question, can we have the transcript of the witness's testimony? The court proposes the following supplemental charge. Members of the jury, I have received your note. Under the law, I cannot read testimony back to you generally. You must have a dispute about the testimony that you are asking about, and you will need to specify exactly what you are in dispute about. If the jury specifies as to what they are in a disagreement about with regard to the statement of any witness, then they may, upon application to the court, have read to them from the court reporter's notes just that part of such witness testimony or the particular point in dispute and no other. Any objections to that as the answer, state?
No, Your Honor.
Defense?
No, Your Honor.
Next question. Can we have the transcripts of the opening and closing statements of the statement of the state and the defense? Have both parties had a chance to review the question?
Yes, Your Honor.
Yes, Judge.
Court proposes the following supplemental charge. With reference to your inquiry, attorneys' opening statements and closing arguments are not evidence. You now have before you all the testimony, exhibits, and evidence that was admitted, and you have all the law before you. Please continue your deliberations. Any objection?
No, Your Honor.
None from the defense.
All right, any objection to the court sending the questions with the answers back to the jurors?
Not from the state.
No, Judge.
All right, thank you.
Thank you, Judge.
You are Deputy Laura. All right, we are on the record in 2019 CR 12495, State versus Taymor McIntyre. Could I have parties announced for the record, please?
Jason Beer, had a big gallery with the shades on it.
John Hunter, Thomas Lane, for Mr. McIntyre, Your Honor.
All right, it's the court's understanding from the deputy that a verdict has been reached in this case. This is what I'm going to tell all the parties who are present in this courtroom. There's not to be any outbursts. If there's an outburst, what's going to end up happening is a deputy is going to tap you on the shoulder. There's no need to get into a conversation with the deputy. That tap on the shoulder is meaning that you are to leave this courtroom and you will only be allowed back in this courtroom if you're going to be a witness. Does everyone understand?
Yes.
Is there anyone who cannot do that? So both parties, for the state and the defense, if you need to talk to members who are currently in court that are either with the state or defense, you may do so now. Otherwise, I'm going to bring the jury in.
Everyone knows to be on their best behavior, Your Honor.
All right, let's bring the jurors in.
All right, for the jury.
All right, ladies and gentlemen, it's my understanding that you've reached a verdict in this case. Is that correct? And is that verdict unanimous? All right, if you will give the verdict form to Deputy Laura, please. All right, if the defendant could please stand. We, the jury, find the defendant Taymor McIntyre not guilty of the offense of capital murder. What did excuse me, no. No, out of the courtroom, out of the courtroom now. All right, ladies and gentlemen, you don't ignore that. Sometimes, as you can tell, people are invested, correct? So it says, we, the jury, find the defendant Taymor McIntyre not guilty of the offense of capital murder as charged in the indictment. We, the jury, find the defendant Taymor McIntyre guilty of the lesser included offense of murder. Does anyone wish to have the jury polled?
Yes, Your
All right, ladies and gentlemen, and do you want them polled as to both counts?
Honor. As to the count of conviction.
All right, you may be seated. Ladies and gentlemen, I'm going to ask you if, in count 2, the guilty verdict for murder, if that is your verdict. If that is your verdict, I'm going to need you to respond yes. Does everyone understand? So we'll start on this end and work our way down. Is this your verdict? Is this your verdict? Is this your verdict?
Yeah.
Is this your verdict?
Yeah.
Is this your verdict? Is this your verdict? Oh, yes. All right. Back row. Is this your verdict? Is this your verdict? Is this your verdict? Is this your verdict?
Yes.
Is this your verdict? Is this your verdict? All right, ladies and gentlemen, what's going to happen now is I'm going to allow you all to have your recess for lunch, and then we'll begin the second phase of the trial. All right, everyone, please rise for the jurors.